Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about the part of estate planning known as the living trust. Now, first of all, I have other videos that I've done on why you should do estate planning and how it's a good idea to move forward on it. But here in the state of California, the living trust is probably the default most important document, although they're all important to be honest with you, but is one of the most important documents that you will have, that you will be able to use, and that you can basically put in there what you want done with your assets and with your property at the time that you pass on. Now, the question, first of all, is why do they call it a living trust? Okay, well, first of all, let's say that you're 35, 40, whatever years old, and your wife or your husband would be, about the same age, give or take. Um, you obviously and your spouse are not planning on dying anytime in the near future. So the way it works essentially is the living trust will put all the provisions that you want in there. It'll have all of the legal mumbo jumbo per se, and then what will happen is you'll go on living. Okay, but the trust will be funded with the real property that you have, with IRAs, student contributions, pretty much everything that you want to be distributed in a certain manner will go inside the living trust, and the living trust will be funded with real and personal property. Now, while you are living, this trust exists. And that essentially is why they call it a living trust. Because while you're living and your spouse is living, you still go on as normal. Okay, you still live. But the mandates of the trust essentially permit you to continue as you have been. And for example, if you're living in your house and you put your house, your residence, in the living trust, that doesn't mean you can't touch it, doesn't mean you can't sell it, doesn't mean you can't rent it out, doesn't mean you can't get loans on it, doesn't mean you can't benefit from, getting income from it, if you have income property, whatever it is. Essentially, all of the current situation that you currently are in will go forward while you're living, and the living trust will take care of that. Okay, we'll have provisions for all of that. Now, when one of you passes on, that will trigger certain events to happen that will essentially change or add a sub-trust to the current living trust. Now, let me explain. When you make the living trust, let's just assume it's a usual family, spouse, and of course in California here, and in many other states, but in California, there's now same-sex marriages, and so if you are married to someone of the same sex, this applies to you as well. It will not apply if you are just living together, okay, or a registered domestic partner. You need to be spouse, okay, for this particular provision to work. Now, when you create the living trust and both of you are, alive, everything goes as is, and again, it tells what income can be distributed and so forth. Now, when one of you passes on, there's all kinds of provisions in the living trust that you can use to protect your spouse and your children. Let's say that you have children. One of the biggest concerns that applies here is that when one spouse dies, the other spouse ultimately will fall in love again, get married again, have different kids, and maybe whom they marry again will have their own kids, and it'll be what's called a mixed marriage. And let's say that you worked 20 years to save for that house you're living in, and ultimately you want to make sure that your kids get that house. You of course want your spouse to benefit, be able to live there, and also if it's a rental property, you want your spouse to be able to get the income and to do all that is necessary in which to benefit from the property while your spouse is alive. But what you don't want is you don't want your spouse to take that property and then maybe give it to the new spouse or kids that are not your kids but are other kids. So that is essentially what could happen in which to go forward. Now, let's add another word to what the living trust. Okay, the living trust is usually revocable or irrevocable. What does that mean? If it is revocable, that means it can be changed at any time. Okay, it means you can add to it, subtract to it, change the provisions of it. You can work with your spouse and decide what you want to change. And realistically, every 2 to 5 years, you should revisit what you have already done and update it. Make sure that it still has the provisions you want. A lot of times, for example, you will designate someone, should both you and your spouse die, who will take care of your kids. You have a guardianship provision. Maybe 2, 3 years after that, you don't want that person to be the guardian anymore. Okay, I mean it just depends, or maybe some property was already sold, and that's not going to go to the kids anymore because you got another property. There's all kinds of things that could change. So an irrevocable trust is when you both of you are alive, and the living trust is exactly that. Okay, it can be revoked or changed at any time that you guys want to do it. Now, when one of you dies, then that's when things change. Generally, and again, this depends on the provisions and your wishes and your spouse's wishes, but generally what happens is certain property will then be devised to your spouse, and it's for a certain purpose so that when your spouse dies, it can then go to the kids. So you essentially, one, want to give all the benefits to your spouse for the property, but you don't want your spouse to have unconditional control of the property in which to be able to sell it and dispose of it without it going to your kids. So then after you would die, the trust, the living trust, is divided. Okay, or it's a sub trust basically. Part of it goes to your spouse, and again, that part of it is still revocable, can still be changed, and so forth. But part of it becomes irrevocable, and what that means is it can't be changed because you're not living anymore. You have no say in it. You want to make sure that what you and your spouse discussed and how things are going to go to your kids cannot later be changed because of undue influence, because of a new marriage, because of mixed marriage with kids from a different marriage that you never met. So that part of it becomes irrevocable. Okay, and that's the beauty of it. In that 30 years after you passed away, or 40 years or whatever it is, you're still going to be protected, your wishes are still going to be followed, and so forth. And with this irrevocable trust, there's different sub-trusts that can be made, which I'll discuss on other videos. The Q-tip trust, and then there's the marital deduction to avoid taxes, and all this stuff. I mean, there's all kinds of ways of working it. But that essentially is a summary of what is a living trust, how it becomes irrevocable, how it normally starts out revocable, and all kinds of provisions can go from there. So, as you can see, the living trust, while I basically have just bordered the information and summarized in general, because there's lots and lots of other information. It is very important to the estate planning package, and it usually should be done either first or second of all of the ones that need to be done. And it should be revisited every couple years. Okay, if you like the video, click subscribe. Also, be sure to give my office a call or send me an email if you'd like a consultation. The initial consultation is free, and I let you know what can be done, what the costs are, all of that. Okay, more on the coming videos.